Okay, good afternoon. We have a panel change. I think you've been introduced to Judge Harris on my right. He's helping us with the many cases that we have on the docket today, and I think you'll be back on Thursday, won't you, Judge Harris?
Yes.
And Thursday, and we very much appreciate his help and his assistance. I'm Judge Sawaya, and to my left is Judge Palmer, and we're here for one case, and that is KRISTEN DERRICO versus Circle K. All right, so you may proceed. Each side will have 20 minutes. You have a clock on the podium that will assist you in keeping your time.
If it please the court, Thomas Hippelhauser here for KRISTEN DERRICO. We're here today on basically a discovery dispute that snowballed out of control and turned into a dismissal. The facts of the case are in August of 2006, Ms. DERRICO alleges that she suffered from a slip and fall. Within a couple of years after that, she files a complaint against Circle K. Shortly thereafter, she was served with some interrogatories. The key issue is the question of prior medical treatment. Her response was that she didn't recall who she had treated with. That led to a motion for a more definite statement or better answer. She investigated further and gave the same response. That led to a motion for sanctions that initially was a request for dismissal and went in front of the judge, and the judge immediately recognized that she couldn't dismiss the case based on the facts.
Why couldn't she dismiss it?
The case law,
she made a finding that your client misrepresented herself in answering the interrogatories even after she was ordered to answer them more fully. She gave the original answer that the judge said was inadequate. Why isn't that a basis for sanctions?
it's basis for sanctions if the court made that finding. One of our arguments is that she didn't make that finding, but it wasn't appropriate for the sanction.
She instead says, I'm going to consider the less stringent sanction of attorney's fees, right?
That's what she decided to do, Your Honor.
You were there when she made the finding, and your client was there or not when she made the finding that she was going to assess attorney's fees?
I wasn't the trial attorney, and my understanding is Ms. DERRICO wasn't there.
Wasn't that the time for somebody to tell the judge, I'm not able to pay attorney's fees? In which case, the judge has the option of saying, well, if I can't use a least restrictive sanction, then I may have to use a more serious sanction. Shouldn't somebody say, I'm immune from paying attorney's fees because I don't have the money, therefore there is no remedy?
I believe the trial attorney did suggest that he was not sure that she had the ability to pay. The issue at that hearing was that there wasn't actually an attorney's fee hearing. The purpose of the hearing was to ask for the dismissal. The judge announced that she was going to...
Was that an evidentiary hearing?
It was not. Well, there was evidence presented, a lot of hearsay evidence and a little bit of documentary evidence on the...
But did your client have an opportunity to present evidence in response to the motion to dismiss if she had wanted to?
The motion itself was very unclear as to what the Circle K was asking for, and when we got there, they present at that time the evidence that they were going to use to try to make the argument of sanctions. There was virtually no opportunity to review that evidence, and then when the argument went forward, there was a lot of suggested additional documents that were discovered but were never presented to the court. The issues that were presented to the court were very narrow as to, I believe, 5 particular providers, one of which was already previously disclosed. 2 of them were disclosed within the documents that were disclosed, and when the issue came up, the judge on her own decided she wasn't going to dismiss it, and there was a brief discussion as to attorney's fees. The attorney representing Circle K had no knowledge as to what he had invested in time, did not know what his firm was charging, did not have any idea what the costs were. And when that hearing was over, it was understood that there was going to be some kind of an evidentiary hearing as to attorney's fees. What happened was Circle K submitted timesheets, unsworn, unsigned, without serving them on Ms. DERRICO without filing a notice of filing, including items that were specifically excluded by the judge in her verbal description of what she was going to award sanctions for. The day she got those timesheets, she entered an order that violated the Rose standard. So there was no opportunity whatsoever for DERRICO to challenge those.
The basis of the claim for sanctions, that she had not filed any further response to the interrogatory after being ordered to do so, or was it some finding that she had willfully hidden or failed to disclose information?
There was no finding. We do not know what the court
Didn't the judge say that she thought that she'd committed fraud?
The court questioned whether or not it was possible for my client to have forgotten the names of her doctors. That's as far as she went.
But there was no testimony taken on that issue?
None. And one of the things that we point out when we get to our discussion of whether there should have been a stay, the result of all this was that there was a deposition that was scheduled within a few weeks that was canceled. At that deposition, all of this supposed undisclosed medical could have been presented to Ms. DERRICO for a response. But because of what the court ruled, that never happened.
My notes tell me that Circle K argued the case should be dismissed because 2 years had lapsed since the entry of the sanction order that remained unpaid. Is that right? Was it 2 years that had lapsed?
Just short of 2 years, that's correct. And if you look at the transcript or the record, what you'll see is approximately 8 months after the order was entered, Ms. DERRICO's attorney filed a motion for some relief from that stay, and that was answered by a 57-105 motion for sanctions for violating the order. That's how serious Circle K was taking that stay, that we couldn't even argue that we should be relieved from the burden of it. The court rightfully denied that motion. The main issue that the court, I think, needs to review is the issue of the Rose standard here. We are completely convinced that there was that Circle K hid the ball on the attorney's fees. The gross miscarriage of every notion of fair play.
Does the Rose standard apply to sanction attorney's fees the same way it applies to prevailing attorney's fees?
There's a split in the DCAs, and this DCA has not ruled on that issue. But we believe it should, for precisely the reason we're here now. We don't know what the judge ordered for attorney's fees. There's things in that affidavit that are clearly in violation of all the standards for evaluating attorney's fees and costs, but because she didn't break it out, we don't know if she included them. All we do know is that her order is exactly to the penny what they were asking for. Examples of what's included. The rules for attorney's fees make it clear you can't get travel time for a lawyer to go to a hearing. They ask for coming and going, and apparently they awarded it. She then rubbed salt in the wound and gave them a mileage amount of approximately $89 for the cost of appearing at that same hearing. So she awarded them attorney's fees.
Would you agree that you didn't answer the requested discovery request as appropriately?
I would suggest that my client's statement that she didn't remember should be taken on face value until she's confronted with it.
Well, I mean, the trial court certainly thought that there was, failure to respond appropriately, and that there was undue delay, and that prompted the trial court to take the action that she did, right? If
you look at the transcript, what she was commenting on was the hearsay statements of Circle K's attorney, not the providers that were actually submitted to her.
Well, what caused this 2-year delay? Why do we have this 2-year delay in this case?
Because the court prohibited my client from doing anything to proceed with the case.
Is it because your client didn't appropriately answer the discovery requests in the beginning?
I don't believe so.
You don't think so?
No. I think she answered to the best of her ability, and if she didn't, she can be impeached.
Well, during this 2-year period, did she make any effort to pay attorney's fees?
No.
Never filed an affidavit of indigence?
No, sir. We asked twice for an evidentiary hearing to determine that. And the first time the judge granted it, and then when we actually convened a hearing, she then denied the opportunity to have an evidentiary hearing. The other thing is when you look at what the court said at the original hearing,
So to get back, I mean, none of this was your client's fault. I mean, she was completely innocent. She did everything she was supposed to do, and this was just the errors on the trial court that caused all this lengthy delay.
I think the court could, if it would be reasonable for the court to find that she didn't answer completely, and that an appropriate sanction could be entered. The sanction that was entered was clearly excessive on both the amount of the penalty, and in their briefs they call it a penalty as well, and on the stay.
If the court had found this was fraud or this was willful, let's say they'd held an evidentiary hearing, that finding would have supported a sanction up to and including dismissal of the lawsuit, correct? I
think the current case law would not allow dismissal under that because they encourage resolution on the merits. I think that the current case law would say use it for impeachment, but it would justify an appropriate sanction.
Well, if somebody indigent, what would that sanction be? If you can't dismiss, you can't require them to pay costs and attorney's fees, what do? You get them to say, I won't lie again for 30 days and submit it within a month?
One appropriate sanction would have been to award an appropriate amount of attorney's fees that could later be used to offset any verdict she got or enter a judgment against her. But what they did in this case was effectively dismiss her case. And it just took 2 years for that to work its way out.
Have you ever seen an award where the court has assessed an attorney's fees to be paid out of any judgment the defaulting person gets?
I have never seen that, but I've never seen one where they enter a fee as large as they did in this case and then stay action until it's been paid. I've never seen that either.
Well, how much was the fee that was awarded in this case?
$3,500.
$3,500.
$3,000.
What the court said the fee was going to be for was the actual amount of time they incurred sending out these shotgun subpoenas, which I believe were a total of 10 subpoenas.
Which would not have had to be done had she answered the question right.
Well, part of what they were listing were sending out subpoenas to providers she had disclosed. She disclosed Citrus Memorial Hospital. They decided to request records that predate the time that she listed, and the cost and prejudice to Circle K for adding a change in date does not equal $3,500. She disclosed that she was a Medicaid recipient. If you look at their affidavit, they spent considerable amount of time talking to Medicaid about disclosing that information. She said she went to Walgreens. They spend a lot of time researching Walgreens. That's in the affidavit. Those things should have been stricken. And when you look at how much is left from what her verbal ruling was versus what she actually entered, instead of the 19 or so hours of attorney time, it should have been about 3.5 hours. If you even believe that a sanction should be entered, granted, it's the court's discretion.
What they were able to find out, though, is that contrary to what she stated, I guess under oath in the interrogatories, she had been to medical providers for exactly the same type of injuries she was now claiming from her slip and fall. Headaches, bad leg, right?
Yes.
All right.
I believe that a close examination of the affidavit versus the Rose Standard, and then you put in the stay, will lead this court to reach the same conclusion that Ms. DERRICO did not get due process, and this is a gross abuse of discretion on the court. And when you look at the comment that she made when she was entering the original verbal order, she knew that she would probably not be able to dismiss this case. That was her statement, but then she said that she would probably be back here on a motion to dismiss for lack of prosecution because of what she was doing. So it appears to us that it's clear that the judge's actual intent was to lead to a dismissal on essentially something that they have failed to establish any prejudice. They had the information. They got the information primarily from information that she provided to them. They could have confronted her at her deposition or at trial.
They never did. They got a lot of the information on their own, and that's how they discovered that, or made the allegation that she wasn't being truthful.
At the hearing and in any of the documents they filed, they never said where they got the information from. They said they did those shotgun subpoenas, but they didn't indicate that any of those shotgun subpoenas actually got them any information. All the information that they presented, with the exception of one doctor, came from taking what the answer she gave, looking at the results of those documents when they come back, and then doing a secondary level of discovery. Genesis, the big one, 22 visits, was listed in Citrus Memorial's Hospital as her primary care doctor. What prejudice did they suffer by...
Why should they have to do a secondary investigation when they're asking her for the information in the beginning?
The judge addressed that she said that it's not prejudicial on their part to have to actually request information found that way versus being found through her disclosure. They still would do the same things, incur the same costs. That's the judge's ruling. And then turns around and awards this outrageous amount of money. I'd like to reserve 5 for rebuttal.
$3,500 is an outrageous amount of money? You think that's outrageous?
For sending out 10 subpoenas, I believe so. When you include travel time of 3 hours to a hearing and $89 for mileage and contacting providers that she did disclose, when you go through it item by item, I
When
believe
does
so.
she disclose them? Because I don't see that. When does she disclose it?
In-
As I see it, she says, I don't know now, but I will research and get back to you.
There are
She said
other
that
questions in the interrogatories. One was, who'd you treat for this accident? And she said, Walgreens, Citrus Memorial Hospital. And if you look at the affidavit, they're included. Are there any liens against your settlement? Medicaid. And you look on the affidavit, and contact and communication with Medicaid is on there. She didn't disclose it in 16. She disclosed it in other interrogatories.
All right, you've got 4.5 minutes left.
Thank you.
Good afternoon, Your Honors. My name is Jerry Tolton, and I am here on behalf of Circle K. It's very clear from reading the record that Judge Thomas, over in Inverness, was frustrated.
What's the standard to award sanctions for an alleged discovery violation? What do you have to prove to get sanctions?
The judge has to find that there's been a willful disregard.
Is a willful disregard a factual determination?
Yes, Your Honor, I believe it is.
What evidence did the trial judge take in order to determine whether or not this was willful?
Here, the judge, the evidence that she took was from the plaintiff's own lawyer. And what the lawyer said was...
Well, what lawyers say isn't evidence. What evidence did the judge have, if any, before her when she made this decision?
She had the plaintiff's second round of answers to interrogatories in which the plaintiff repeated the same deficient answer that the judge had already said was deficient.
And how do you determine that she willfully failed to disclose knowledge that she had from that interrogatory answer? Is it at least theoretically possible that it was not willful, that she didn't remember it, for example?
Well, the judge, as Judge Harris pointed out, found that to be incredible.
Well, but how do you find it to be incredible if you don't take testimony? Don't you have to see the presence of the witness, allow questions to be, what if you had a witness who got on the stand and said, I had amnesia for the last 10 years. That's why I didn't do it.
And Judge
Then you
Palmer,
wouldn't be able to do sanctions, right?
let me answer your question this way, because I think it goes to the entire theme of the case below. You're right. If it's my case, I'm representing the plaintiff, I bring him into court. I ask him to raise the right hand, I have the judge swear him in, and I take testimony. The problem in my view, with this case, is that this court has no record on which to reverse or find that Judge Thomas committed an abuse of discretion.
We have a record that shows that a trial judge found sanctions for a willful violation without taking any testimony on whether or not the violation was willful. Don't we have that in the record?
I would challenge, Your Honor, to the fact that they did come in with a second set of interrogatory answers, sworn interrogatory answers by the plaintiff. That is evidence of a nature in which she disregarded what the judge had told her to do the month earlier. And
what did the judge tell her to do a month earlier?
To provide better answers to interrogatory.
What if she had no better information to provide?
I guess she could have said that in her interrogatory answer, but Your Honor, Judge Palmer, that's not what she said. She said, I will get this back to you as soon as I have time to research it. Now, mind you, this was 9 months later.
Let me ask you this then. Was the sanction entered because she didn't answer the second interrogatories the way she should have, or was the sanction entered because the trial judge found she was fraudulently hiding information? Those are two different things in my mind.
I believe it was the first. I believe what happened was when Circle K's lawyer went in there and said, look, we didn't have any option. We sent out blind subpoenas all over Citrus County to figure out where this lady had treated. and we're getting stuff back. And by the way, that stuff was provided to Ms. DERRICO's attorney. So at the least, he can sit here and modify the answers himself and say, Ms. DERRICO, do you agree? Do you disagree? If you look at the transcript of the hearing from June 15, 2009, what Ms. DERRICO's attorney did say is, I have no reason to dispute these are her records. It's her date of birth, it's her name, it's her social security number. So I have no reason to dispute it.
And that's information that Circle K gathered on their own and provided to them?
That's correct, Your Honor. That's correct.
I have little doubt that this is a case that potentially could result in sanctions and maybe even in dismissal sanctions, not just attorney fee sanctions.
Mm-hmm.
I am concerned whether or not you procedurally went about it in the proper way and proved what you needed to prove to get those, or whether you need to prove something further before you can get whatever sanctions you're entitled to.
Judge Palmer, I've thought about this. So I'm trying to figure out, and I do trial work as well, and I'm trying to figure out what I would do. I guess I could subpoena Mrs. DERRICO to come and tell me that she was being truthful. But I'm never going to get, nobody is ever going to get a party to come in and say, yes, I willfully lied, I knew the answers, I just didn't feel like giving them to you. That's just not going to happen.
No, but if she comes in and she's asked why she didn't do it, and she says why she didn't do it, the judge can at least determine her credibility and decide whether he believes her or not.
But Judge Thomas had the ability to do that. She said, do you have this information? If you have this information, get it. She repeats the same answer. If she would have just said something similar to what you just said, Judge Palmer, that might have been a different case. I'm not sure. But she didn't. She gave the exact same answer she gave the first time. I'll research it and get back to you. I'll research it and get back to you is not, I can't remember.
When you submitted this information you discovered to the court, counsel was there for her, right?
That's right.
Was there a concession that those were her records?
That's right. Yes, Your Honor, there were.
That's in the record?
That's in the record. And in fact, and you pointed this out, Judge Harris, in fact, what Judge Thomas says on page 21 of your supplemental record before this court, hey, I believe that your client has committed fraud on this court. And this is exactly what Mr. Miller...
Okay, now that seems to not go to the, I'm sanctioning her because they didn't answer the second round. That seems to go to the underlying, she must have been lying when she answered it in the first place.
So
right?
what's the difference,
There's no
Judge
fraud
Palmer?
on the court simply by giving the same answer in round two, right?
What's the difference, Judge Palmer, between what she's saying there and a finding of willful disregard? She's saying, on the one hand, I think she might have committed a fraud.
Well, my question is, how does the trial judge determine she committed a fraud without taking any evidence to determine that? If the only evidence is she answered interrogatories that says, I'll get around to it, and when they said, give us better answers, she said, I'll get around to it. That doesn't sound like fraud to me. I mean, you could potentially sanction them for not obeying my order to give better answers.
And that's what they did. That's what she did.
Well, it sounds like she gave it for fraud, though. Fraud's a very different thing than a sanction for failure to obey an order is different than a sanction for fraud.
Judge, she explicitly said on that record, I'm not going to dismiss this case. In other words, Circle K was in front of Judge Thomas saying, dismiss this case, dismiss this case. She said, I will not. She said, I'm going to give a lesser sanction. I'm going to impose, your expenses. Send me your information, and then I will...
Did you provide attorney fee and cost information to the court without providing opposing counsel with it?
No. No. That has been misrepresented before this court with all due respect. Mr. Hippelhauser may not realize this because he may not have had the benefit of his trial counselor's correspondence file, but I wanted to go over that. On June 24, 2000, the hearing was June 15. On June 24, 2009, Circle K's lawyer, trial lawyer, sent Brent Miller, plaintiff's lawyer, a copy of the proposed order following the hearing, including attorney time slips, rates of hours, and cost, the cost of the subpoenas. Said, here's my order, here's the summary of fees and cost. Let me know if you have any objection. Otherwise, I'm presenting this to the court. Mr. Miller wrote back he sent a fax July 23rd, nearly 30 days later, saying, not commenting about what was sent to him on June 24th, saying, let me have your retention agreement between you and your client. The lawyer wrote back, our lawyer wrote back, Circle K wrote back on July 27th, 3 days later, we don't have a retention agreement, this is an old, long-standing client. Here again is the proposed order. Let me know if you have any objections or if you need any other information, otherwise I'm sending this to the judge. On August the 10th, Those time summaries and cost expenses were sent to Judge Thomas, CC'd on Attorney Miller. This was not ex parte. And this goes to my earlier point, Judge Palmer. At any point in time, Mr. Miller could have said, I'm filing an objection. Now, I don't believe that Judge Thomas had an obligation under a sanctions rule to hold a row-type hearing. But make that part of your objection. This is a case of sitting on your hands and doing nothing, waiting until the death knell, is entered, and then coming back and complaining about it. And I think this is a classic case of all the arguments they have made in their brief, and mostly in their reply brief, could have been made in an objection before Judge Thomas, and any errors could have been corrected at that time. It wasn't done. It's the most fundamental premise of appellate law that I know. You can't sit idly by and then wait until the case is over, and then when you didn't object, raise it on appeal. And I think that's exactly what's happening here.
Let me ask you this. When the order was entered which awarded sanctions and stayed the proceedings until the sanctions were paid, did the appellant have any appellate relief available, or did he have to wait till the dismissal of the lawsuit because now there's a final appealable order? One of the complaints that the order was entered and you didn't do anything for 2 years. Well, after 2 years, there was a dismissal and therefore a final appealable order. Was there anything the appellant could have done before the 2 years ran and the dismissal was entered if they had a complaint about that order, or is that like other orders that predate a final order that you could just got to wait the case is over and then you can argue whatever you want?
And remember, Judge Palmer, the plaintiff filed two motions after this order telling her she could do nothing. So she did take further action in court. She filed a motion for her counsel to withdraw. It was never set, never heard. And she also filed a motion to set aside the stay, which was heard. She never asked for an evidentiary hearing. She never filed a financial affidavit of any kind. She had notice that there was going to be the motion for sanctions that they say was vague and confusing.
Well, if their argument is it wasn't appropriate to enter an order of sanctions against my client.
Yes, sir.
When does that ripen for appellate review? At the end of the case, or does it ripen somehow at the time that they could have made a complaint then?
I believe they would have had an opportunity to file a writ of cert if that's what they would have. But I don't think they would have had to go that far, Judge Palmer. I simply think all they needed to do. Remember, look back at their brief. The trial judge, they asked for an evidentiary hearing on ability to pay. The trial judge said, okay. Now, this is critical. Trial judge said, okay. This was a year after the sanctions order had been entered. What does the plaintiff do? Nothing. Judge Thomas gave them what they asked for. They did nothing. Did not set up for hearing, did not ask for it, just didn't follow up. I don't know how to explain that. But I don't see where the judge committed any abuse of discretion.
When you then go in for a motion to dismiss the action because the sanctions have not been paid, who has the burden of proof with regard to ability or inability to pay? Do you have to prove she had the ability, or do they have to prove she didn't have the ability?
I would argue they would have to prove that she did not have the ability. They're the one making that argument. They kept making it over and over.
Well, your argument is the case should be dismissed because they haven't paid sanctions. You couldn't get contempt without proving that they have the ability to pay. Can you get dismissal without proving they have the ability to pay?
My argument, Judge, with all due respect, is that this case was dismissed because the plaintiff violated 3 orders of the trial court. Violated the discovery order, violated the motion for the order on the motion for sanctions, and then violated a 3rd order when the judge says, I'm going to give you another 15 days, pay or get out, your time's up, enough is enough, and she did not do anything. And I just don't believe this court or any court can reward a party for sitting on its hands and doing nothing, and then they come to this court and say, we're throwing ourselves on the mercy.
Okay, the first order is the actual discovery order.
Right.
Before we get to sanction orders.
Yes, sir.
Is it your position that a basis for the ultimate dismissal by the trial court was that first discovery problem? Or was it simply the failure to abide by the sanction order that led to the dismissal?
I'm not sure I could parse between them, Your Honor. I think Judge Thomas was just frustrated. You know, I think she was she didn't have any more bullets in her gun. She didn't know what else to do. You know, they kept coming to her and saying, well, you know, we want an evidentiary hearing. Okay, go ahead, set an evidentiary hearing. This is Judge Thomas, a year after the sanctions order. They do nothing. I'm not sure what the judge can't practice law for the plaintiff. So I'm not sure what in the world that Judge Thomas was supposed to do. She did not dismiss the case the first time it was requested. She did not dismiss the case the second time it was requested.
Did she ever order any kind of remedial in the sense of, did she ever come back and say, once again, now that we have this information, we need a complete answer to interrogatories, and if you don't give us, I'm going to sanction you? Because most of those sanctions have sort of a cure, right? I'm going to sanction you unless you, within 15 days, provide all the information. In this case, there was not a second round of provide the information, right?
There was, wasn't there?
There was a second.
Well, there was this. I'm sorry. There was two set when the second set of interrogatories came out.
Right.
And then there was the sanction hearing. At that sanction hearing, was there a give it to him again, or was it just related to fees?
There wasn't a give it to him for a third time. Okay. She'd had 2 times to amend. She just didn't do it. Okay. So I do believe that and one other point I want to address that they made, which was, and this I also think is a problem. They argue that, and if you read their initial brief, I was a little confused about the relief they were requesting, because they seem to say the sanction was permitted, was not abuse of discretion, had the right to do it. And then they say, but what should have happened is the court should have lifted the stay and then let the case proceed, and then if there was a verdict, Judge Harris, you picked up on this. If there's a verdict, we'll just deduct the sanctions award from the verdict. I don't think I need to spend much time on that. If it's a defense verdict, obviously we never get paid. The sanction is never purged. If it's a settlement, the sanction never gets paid.
What's the legal basis for the ability to stay the proceedings until the sanction is paid?
Rule 1.380.
Okay, and is there a ability to pay requirement under that rule?
There's the indigency statute. No, sir. There's the indigency statute, which I cited in my brief, in which the plaintiff, if or any party claiming to be indigent, files an affidavit and has the court pick up the cost of the litigation. The point I was making in my brief is that you got to do something. File an affidavit. Come to court. Raise your right hand. Do something. Don't just sit there and do nothing, and then when you get, the guillotine, come to the court and say, I don't know what happened. Judge Sawaya pointed it out. This is a case in which the plaintiff is blaming everybody, including the trial court, for what happened to her. Now, she didn't just miss this by a little bit, Judge. She missed this swinging wide. And the reason she missed this, with all due respect, is because a year after this incident, she had an auto accident in which she attributed all of her pain and injury to that auto accident, and she didn't want Circle K to find that out.
Is that in the record?
That is, yes, sir. That is in the hearing of June 15, 2009. So we would ask respectfully for the 50CA to affirm the trial court's.
When was she in that accident? She was in the accident when?
She had the the auto accident in, I believe, of July of 2007. I may be wrong about the month, but it was 2007.
And the slip and fall was when?
August of 2006. Her complaint against Circle K, against my client, was filed August of 2008.
All right.
Thank you, Your Honor.
Okay, thank you.
Counsel, respond to his statement that apparently you misrepresented that he had not sent notice of his attorney's fee affidavit to your client.
I went through the trial notebook and saw none of the correspondence that he's talking about.
But you're not denying that it existed. Did you talk to trial counsel?
I have, and they said they did not receive it. So I don't know what he's talking about. I haven't seen it, so I can't.
He said there was a CC at the bottom of the correspondence where it indicated that it went to you or to your predecessor.
I did not see any correspondence that went with the affidavit or with the proposed order.
And what about his contention that you all had an opportunity to have an evidentiary hearing but never had it on the issue of ability to pay?
We filed a motion asking for it, and the judge granted the motion, and then made the comment that it was going to be a very short hearing, and then...
Did you schedule a hearing?
No, we didn't.
Did you attempt to present testimony?
We did not.
You didn't make any proffer as to, on the inability to pay?
No.
It's your burden to prove it, isn't it? Inability to pay is your burden.
I think the standard is they have to prove the ability to pay.
Who has the burden? Are you saying they do?
The party making the accusation for the ultimate
What's the
sanction.
basis of that contention?
Where does...
That's a defense, isn't it?
Well, we asserted it.
If you're asserting that you don't have the ability to pay, you have to prove it, not them.
We made the allegation that she didn't have the ability to pay. They
But you
presented
didn't-
hearsay statements
they-
that she did.
But you just said, the trial judge said it for, said you can have a hearing, you never said it for a hearing.
That's correct.
No, you didn't prove it then.
I would concede that.
And we have no proffer or anything in the record to let us know that she didn't have the ability, right?
Just the statements made by counsel at the hearing. Okay. The issue on the auto accident was disclosed in the supplemental interrogatories. That she explained that she was pushing a car and was hit by a door, and that she suffered injuries. So the way they found out about that was that she disclosed it. Our contention here is that, and you could tell from the discussion you had with counsel, we don't know why the judge entered the order she did, because she never made any findings. Every single order she entered was simply pay a sanction, your case is dismissed, your motion's denied. And things she said in her verbal rulings in court never appeared in any of her written orders, and yet especially with the sanction itself, the dollar amount is completely contradictory to what she said she was going to do. So part of what we're arguing is, how can we respond to the judge's orders if she doesn't actually put anything in the order? As for the issue of raising it at trial, I personally argued the last hearing on this matter, and I raised every one of these arguments to the judge, that the order violated the Rose standard, that there weren't proper affidavits. I argued all of that. And so that we believe we preserved that for appeal. And like you were asking him, when were we supposed to bring this appeal? There was no final orders in front of the court, and we argued that that was the nature of the way she ruled, that she knew that there was going to ultimately be a dismissal for lack of prosecution if the client didn't pay this money, and that's what eventually happened. When that dismissal was finally entered, we filed our appeal timely. So we didn't sit on anything.
Okay, thank you.